Now let's look at two important concepts. One, theory of separation of powers, which is attributed to French philosopher Montesquieu, although he has not used the term separation of powers, but he has used the term distribution of powers. So one is theory of separation of powers, and the other is the doctrine of checks and balances. If all the kinds of powers are available with one body or one individual, then it leads to tyranny. It leads to despotic rule. Montesquieu said, if we want to establish a democratic system, for that we need to distribute the powers into three different organs. For example, we had a king or we had a dictator. All the powers were concentrated in the hands of a king. The king was the judge, jury, and the executioner. King was making laws. King was implementing laws as well. And there was nobody to tell the king whether the laws are good or bad, whether the laws are rational or irrational, whether the laws are reasonable or unreasonable, whether the laws are just or unjust. So the king was in a sole position to determine what kind of laws need to be passed, how these laws are to be implemented, and he will also punish people for violating these laws. Montesquieu said, this amounts to tyranny. This amounts to despotic rule. We need to distribute the powers, create a body which can make laws, create a body which can implement the laws, and create a body which can provide justice to the people, which can determine and decide whether the laws, whether the executive is doing its duty to the best according to the Constitution. That is why Montesquieu said, let's have a distribution of powers. Let's have a system where powers are separated in a watertight arrangement. That is why create three organs of a state. The job of the legislature is to legislate, which means make laws. Lawmaking is the domain of legislature. Implementation of these laws is to be given to the executive, and the judiciary will punish culprits as well as determine the constitutionality of these laws, whether these laws are in agreement with the Constitution or do these laws violate the Constitution. Watertight arrangement means those who are part of legislature should not be part of the executive. Those who are part of the executive should not be part of the judiciary. Those who are part of judiciary should not be part of the legislature. That means Montesquieu said, distribute the powers. All powers should not be concentrated in one hand or in one body or in one institution. Distribute them. Create one entity called the legislature, which will make laws. Create an entity, executive, which will implement the laws. Create an entity, judiciary, which will determine whether these laws are constitutional or unconstitutional. And judiciary will punish those who violate these laws. And those who are part of the executive should not be part of judiciary or legislature. Those who are part of legislature should not be part of executive, should not be part of judiciary. And judiciary should also be separate in a watertight arrangement. Members of the judiciary should not be part of legislature or the executive. In case of United States of America, which is considered to be the first polity to implement separation of powers, Article 1, Article 2, and Article 3 of the US Constitution implements theory of separation of powers. Article 1 says all the legislative powers are vested with the Congress. This is not Indian National Congress. Congress is the Parliament of United States. And in United States also, the Congress, which is the Parliament, is bicameral, which means there are two houses. House of Representatives, Senate. House of Representatives, lower house. Senate, upper house. All the legislative powers under Article 1 are available with the Congress. Congress is the only law-making body. All the executive powers are given to the President of the United States of America and his secretaries, his ministers, for example, Secretary of State, Secretary of Defense, Minister of External Affairs, Minister of Defense. All the executive powers are vested in the President of the United States of America. And all the judicial powers are vested in the federal court, the federal Supreme Court, and all the states in US have their own Supreme Courts as well. So clear-cut separation of powers. One organ, Congress, legislature will make laws. Executive, President of United States of America and his ministers will implement the laws. And judiciary, the federal Supreme Court and the Supreme Court of all the states will determine the constitutionality of the laws passed by the Congress, will determine the actions of the executive, whether they are constitutional or unconstitutional. And they are separated in a watertight arrangement. Watertight arrangement in the sense, is the President of the United States part of the Congress? No. Are the secretaries of the state or the ministers part of the Congress? No. Are the judges part of the legislature or the executive? No. Clear-cut separation of powers. That too in a watertight arrangement. This is what we call separation of powers. This tripartite system, three-way system of legislature, executive, judiciary, this concept is attributed, as I said, to French philosopher Montesquieu, although he did not use the term separation of powers, he used the term distribution of powers. In his work, In the Spirit of Laws, which was written in 1748, Montesquieu described that this political power should be distributed into a legislature, executive, and judiciary. Why? Montesquieu's approach was that all these different kinds of political powers, executive, legislative, judiciary, these should not be concentrated into one organ, because then we will become a despotic regime, a tyrannical regime. That is why the power should be distributed. And the similar concept was expanded by the former President of the United States, James Madison, who said concentration of powers is tyranny. Concentration of all powers, legislative, executive, judicial. If these powers are concentrated in one body or one individual, this system may just be pronounced as the very definition of tyranny, a despotic rule, a horrible rule which should be opposed. But United States not only implemented separation of powers, along with separation of powers, United States implemented a doctrine called doctrine of checks and balances. What does that mean? Theory of separation of powers, if looked at individually, in isolation, may also be problematic. Problematic in the sense, look at me carefully. Separation of powers, one concept is that all the powers should be distributed into three organs. One organ should not influence the other organ, which means only legislature should pass the laws, judiciary should not pass the laws, executive should not pass the laws. Implementation of these laws should be given to executive, legislature should not implement these laws, judiciary should not implement the laws, and judiciary should sit on the judgment whether the laws passed by the parliament are constitutional or not, whether the actions, whether the rules issued by the executive, whether the implementation by the executive is done fairly or unfairly. No organ should influence the other organ. But if no organ influences the other organ, will it not lead to injustice? Will it not lead to some problems? Problems such as, what if legislature passes a bad law? What if the executive implements or passes unreasonable rules or decides not to implement these laws? And what if judiciary, whose job is to punish the culprits, decides to punish only the blacks and not the whites? Decides to punish only the women and not the men? Shouldn't there be a check on each other? This is where constitutional experts, this is where the makers of the US Constitution, they decided, yes, we should have separation of powers, where one body, legislature, another body, executive, another body, judiciary, but at the same time, we should not have a complete watertight arrangement. Yes, no member of executive should be part of legislature. No member of legislature should be part of the judiciary. But at the same time, one organ should keep a check on another organ. Which means if legislature passes a bad law, judiciary should keep a check on the legislature and decide that this law is unconstitutional. What if executive is doing something wrong? Just like what Donald Trump did. Donald Trump was accused of treason. If the executive, head of the executive, who is the president of the United States, if he commits treason, if he commits high offenses against the state, he should be impeached, removed by the legislature. So executive is kept under check by the legislature. If the president of the United States does something wrong, is accused of treason, legislature should have the power, should have the responsibility of impeaching the president of the United States, removing the president of the United States from his office. And what if judges, they are partial, they are unfair, they are unreasonable, they are unjust? Executive will appoint the judges, and legislature should be in a position to remove the judges as well. This is what we call doctrine of checks and balances. Yes, legislature will pass laws, executive will implement the laws, judiciary will punish the culprits. But what if the judiciary is not doing its job properly? It will be kept under check by the legislature and the executive. Executive will appoint judges, and the legislature will have the power to remove judges as well. If the executive, the president of the United States, is not doing his job properly, is committing offenses, legislature should have the power to remove the executive from his office. And what if legislature is passing a bad law, unreasonable law, unjust law, unfair law? Judiciary should have the power to strike down that law as unconstitutional. This is what we call the doctrine of checks and balances. What about India? In India also we have the separation of powers. For example, legislature is the parliament and the state legislatures, state legislative assemblies. Judiciary, we have the Supreme Court and the high courts. Executive, we have the president, we have the prime minister, we have the council of ministers, we have the governor, we have the chief minister in the states, we have the council of ministers in the state level as well. Separation of powers. Clear? But at the same time, doctrine of checks and balances. If a law is passed by the legislature which goes against the constitution, for example, the example I gave you of section 66 capital A, it was struck down by the judiciary because it was unconstitutional. Executive is kept under check by the legislature. Prime Minister can be removed, President can be removed, Council of Ministers can be removed by the legislature. Judiciary is kept under check. How? Executive, who is the President, appoints the judges. Judges can be removed by the President based on the resolution passed by the legislature. Just like what happened in Pakistan. The Prime Minister of Pakistan, Imran Khan, was removed from his office when the legislature of Pakistan passed a no confidence motion against the Prime Minister. So Prime Minister is kept under check by the legislature. Legislature is kept under check by the judiciary. Judiciary is kept under check by the executive as well as the legislature. How? Executive appoints the judges. An executive has the power to remove the judges as well based on the resolution passed by the legislature. This is doctrine of checks and balances. But there is no strict separation of powers in India. There is strict separation of powers in United States. And it is possible because United States is a presidential form of democracy, where president is the head of the government. Article 1 of the US Constitution creates Congress. Article 2 creates the office of the president. Article 3 creates the judiciary. And this separation of powers is in a watertight arrangement because the president is not the member of the legislature. His ministers are not the members of the legislature. But India follows parliamentary form of democracy, just like United Kingdom. And in a parliamentary form of democracy, executive is drawn from the legislature. Prime Minister Modi is part of the executive. He is also part of the legislature, Lok Sabha. Ministers are part of the executive. They are part of the legislature as well, just like in United Kingdom. And this is possible because we follow parliamentary form of democracy, not the presidential form of democracy. And in a parliamentary form of democracy, there is no separation of powers between executive and the legislature, because executive is drawn from the legislature. You have to be part of the legislature in order to be part of the executive. And in fact, directive principle of state policy under Article 50 of the Constitution, this was the question asked in your prelims examination as well in a particular year. DPSP under Article 50 calls upon the Parliament, calls upon the state of India that you should separate the powers between executive and judiciary. That means there should be a separation of powers in India, not between legislature, executive and judiciary, but there should be separation of powers between the executive and the judiciary. How? We have executive, we have judiciary. Office of the district collector. You're all aspiring for civil services examination. I suppose majority of you want to become an IAS officer. And as an IAS officer, you are dreaming of the post of a district collector who is the head of the district. This office of the district collector was created in 1772 by Lord Warren Hastings. And the role of the district collector was dual. He or she performed dual role. One, executive role, and the other, judicial role. In the executive role, his job was to collect the taxes. Collector, as the name suggests, he has to collect something. What is it that he has to collect? Collect taxes. So the job of the collector was to collect taxes. Executive role. And the job of the collector was also to punish people who committed crimes. So the district collector, who was also known as district magistrate, performed two roles, executive role as well as a judicial role. And this continued till 1973 as well in India. And it was in the year 1973 that Criminal Procedure Code was implemented in India. And this Criminal Procedure Code removed the judicial powers from the district collector, snatched these powers from the district collector, and gave these powers to judiciary by creating a body called a district judge. So 1973 onwards, now we have a district judge who will punish people for committing crimes. And the job of the collector is only the executive role, not the judicial role. So we implemented Article 50 of the Constitution, which called for separation of powers between executive and judiciary in the year 1973 when Criminal Procedure Code was implemented. So long story short, we have to understand two concepts: theory of separation of powers and the doctrine of checks and balances. Theory of separation of powers simply means distribute the powers. So the powers that are available with the state create three different bodies: legislature, executive, judiciary. But legislature, executive, judiciary should be separated from each other in a watertight arrangement, which means members of the legislature should not be part of executive, should not be part of judiciary. But at the same time, we have to keep a check on each other. Otherwise, legislature will pass a bad law. Executive will decide not to implement any law or will create its own rules. Judiciary will also become partial, will also become biased, will favor corporates and not the common man, will favor whites and not the blacks, will favor men and not the women. That is why we need to keep a check on these organs as well. And we keep a check. Judiciary is kept under check by the executive and the legislature. Legislature is kept under check by the judiciary. Executive is kept under check by the legislature as well as the judiciary. United States was the first one to implement separation of powers. Along with this, implemented doctrine of checks and balances. But it was possible for US to implement separation of powers strictly because US is a presidential form of democracy. But in India, just like in the United Kingdom, we follow parliamentary form of democracy. And in a parliamentary form of democracy, it is difficult to separate legislature from the executive. Because executive should be part of the legislature as well. Prime Minister and his ministers should be part of the legislature as well. That is why Indian Constitution, it does not talk about separation of powers between executive and legislature. It talks about separation of powers between executive and judiciary under Article 50 of the Constitution, which is a directive principle of state policy. And we implemented this in 1973. How? Criminal Procedure Code was enacted. According to this Criminal Procedure Code, the powers of the district magistrate, the judicial powers were snatched. These powers were given to the district judge. So now the district collector has only executive role. He does not have the judicial role. Judicial magistrate or the district judge, she only has judicial powers. She does not have the executive powers. Theory of separation of powers along with the doctrine of checks and balances.